there is disagreement between the Commission and the government on a point that is important enough to warrant litigation, the Commission can, to use the vernacular, take the government to court. It can bring an application in the federal court, or more probably, announce that it intends to disclose information, and that will prompt the government to bring an application in federal court. And the matter, this question of does the information need to be classified, is there injury from it, the court might be able to come up with a summary that the government and the Commission couldn't realize an agreement on. That whole discussion moves over to the federal court, where a federal court judge would hear representations, and it wouldn't then be simply a question of the Commission trying to persuade the government. The Commission would be making submissions to a federal court judge, the government would be making submissions to a federal court judge, and a federal court judge would decide whether the information needs to be withheld from the public. And that would be the same analysis of, in that case, is the information injurious? And if it is injurious, is it nonetheless, is there a weight of public interest that justifies disclosure of the information, even though there could be some injury to the public interest? So that covers both the process, the types of information we're dealing with, the ways we are going to encounter it, the ways we're going to deal with it, and hopefully the way we will get maximum transparency to the parties, and if we don't, that we end up in court. The next topic is somewhat different. It's not so much about the process as why this process has assumed so much importance in this particular public inquiry. And part of this is not so much a message from the Commission to the parties and to the public as a message that the Commission is getting from the government, and thought it useful to put in this context here because it is very much related to the discussion of how much of this classified information we will be able to get disclosed to the parties and the public. And the position of the government and our understanding on looking at the volume of information that is coming to us classified at a very high level is that the type of information that intelligence agencies gather when investigating foreign interference tends to be especially sensitive. And there are several reasons that we can see for this, or that we've been advised about for this. One is that the methods used to gather foreign interference information often include highly sensitive sources, such as human sources, whose lives are at risk, or technologies, that is, investigative techniques or methods the government has of gathering information that it simply does not want our adversaries to know about. Another reason is that the disclosure of foreign interference information can be especially harmful to Canadians or the individuals or the Canadian public interest. That, of course, is closely linked to the first point. And another point, and again, this will be for the witnesses on Thursday to convince you of or explain in greater detail. Any disclosure of foreign interference information that comes out of this Commission of Inquiry will be analyzed. I say very sophisticated intelligence agencies. I think most people would observe among the most sophisticated intelligence agencies in the world will be analyzing every bit of information that comes out of this Commission of Inquiry. And they have the ability, as we've seen just in popular culture and in what we know from our own understanding of the ability to aggregate information, these intelligence agencies have massive data banks of information and have the ability to take the crumbs that come out of this inquiry and combine them with that information and draw conclusions that are very difficult to predict. And that's part of the problem, is it's hard to know what they can do with the information. All we know is that we are dealing with foreign intelligence agencies, that if there is a way to extract every drop of value from any piece of information that comes out of this commission, they have that ability because of the sophistication of their intelligence apparatus. And so a very large proportion of the information that has been given to the commission to date is classified at the very highest levels. The process is ongoing. We are still asking for and receiving information, and so we don't have definitive, we don't have the data to make a definitive analysis yet, but we've been working in this area for some of us all of our careers, and we are able to observe that of the information the Commission is receiving, a very high proportion of it is classified at top secret or above, typically above. And we were able to come up with a rough comparison, just to give, I know that for some of you, you were involved in the Public Order Emergency Commission or are able to have reference to it. This is a rough comparison because we are still in the process of gathering documents and haven't even gotten to the stage of admitting exhibits. We don't have an apples to apples comparison. We can't compare exhibits to exhibits here. But on the logical inference that there is going to be a rough order of magnitude relationship between the volume of documents that come in and their classification and the number of exhibits that get filed, it's, we think, still illustrative that in the Public Order Emergency Commission, which, remember, or if you weren't there, I'll remind you, I'll tell you, it was a public inquiry that involved a high volume of national security information. Those of you who were involved in it got used to seeing highly redacted, totally blacked out pages because there was a high volume of classified information. And yet, less than 0.5% of the documents filed as exhibits, and these would all have been obviously in the closed proceedings, were classified as top secret. And again, it's a rough comparison, but to date, 80% of the documents that the Commission has received are classified at some level, and 80% of those are classified at top secret or above. So acknowledging that it's not, that we're comparing exhibits to raw production, it's not really an apples to apples comparison, just you can see the difference in the proportionate level of classification. You had a national security public inquiry in POAC, but it did not generate nearly so much top secret and above classified exhibits as can be anticipated in this hearing. Now, these are the challenges we face, but the Commission has been mandated, and you've seen this in the terms of reference and in all of the public statements of the Commission, it is dedicated to making as much of this information public as is possible within the law, and it has the tools to do it. Frankly, if any Commission of Inquiry could do it, this one can. And this week of hearings is where we hope to get your input on how we can do that better, because some of you have national security litigation experience. All of you represent clients who have perspectives that aren't nearly as familiar to us as they will be to you. And so it will be input from you both during this week when you tell us how better to get redactions lifted, how better to get summaries prepared, how better to convince the government that information should be disclosed even though it's potentially injurious. That is how we will be even better equipped, is from input from you, both this week during this hearing and on an ongoing basis as we consult you to help us get through this with as much disclosure as possible. Thank you.
Merci, Monsieur Cameron.
Thank you, Mr. Cameron. So that is it for today. Now, tomorrow, in order to allow yourself to prepare your day, we'll be having a full day of work. So we'll be starting at 10 a.m. and we expect to finish, depending, of course, how things happen, at up till around 4:30 p.m. So, hoping to see you tomorrow morning. Have a good evening.
Please à l'ordre. The hearing is now adjourned for the day. La séance est maintenant closed.